Hi, I'm Eric Johnson. If you're feeling as if you have little or no control over how you and your spouse will go about making decisions that need to be made in your divorce, this video will tell you about your options for settlement instead of litigation and going to trial. I'm going to discuss 3 options available to you: mediation, collaborative law, and arbitration. You may or may not be aware that you must file for divorce through the courts, but you may or may not be aware that you do not have to prepare for and go to trial to get a divorce. If you and your spouse reach an agreement resolving all the important issues, such as child custody, child support, division of marital assets and debts, then the court will accept your agreement and make it an order without you having to go to trial. You also may not be aware that most divorce cases don't go to court and in fact do settle because the parties settle all the issues. You have probably heard that the most common way of divorcing parties reaching agreement and settling their case is through what's called mediation. Mediation is a good option, but not your only option for discussing and reaching a settlement agreement. Mediation does not appeal to all divorcing people and does not work for every divorcing couple. So I'm also going to talk to you about collaborative settlement and about arbitration. But before we discuss any of those, I want you to be aware of another settlement option that few attorneys will tell you about. That's engaging in settlement negotiations person to person with your spouse. You are not required to utilize a lawyer or a mediator or an arbitrator to reach a settlement. If you and your spouse can and do agree on how you're going to resolve all the issues in your divorce, and your agreements don't violate the laws governing divorce, the court will accept such an agreement. So before you spend a lot of time and money with lawyers or settlement facilitators, if you and your spouse trust each other and care enough about each other to be cooperative and compromising, keep this option in mind. Once you reach an agreement, no matter how you reach an agreement, it would, however, be reckless not to have your tentative agreement reviewed by an attorney to ensure that it covers all the bases and can be enforceable. As we discuss your settlement options, consider the process that not only works quickly and efficiently, but the process that also addresses and respects you and your family's values and concerns. Okay, now let's discuss mediation. Mediation is one of the most common options for dispute resolution. Mediation is often misunderstood because there are many misconceptions about it. Mediation is conducted by a neutral third party, the mediator. Some people think that a mediator can substitute for a lawyer and a judge, kind of a 2-for-1 or even a 3-for-1 deal. That's not true. The mediator is there to help you address your divorce issues and discuss how you might reach agreement to settle them. That's it. Mediators are not judges. Mediators cannot decide issues or order you or your spouse to do anything. They cannot give either party legal advice, and they cannot testify as witnesses of what happens or what is discussed in your settlement negotiations. You can bring a lawyer with you to mediation, and in our opinion, you should, because a lawyer can give you his or her opinion of what your spouse proposes and advise you on what you can counter with or propose yourself. Your lawyer can help you ensure your proposals and offers are legally feasible, too. Your lawyer can be a check on your emotions to ensure you don't let anger or fear affect your decision-making. And your lawyer can level the playing field when there's been a power imbalance in the relationship with your spouse. You can engage in mediation at any time, before you file for divorce or after you've filed. In fact, when a divorce case is filed in Utah, the parties are required by law to attempt settlement through mediation or some other form of alternative dispute resolution before they can go to trial. Other videos on this page help describe the divorce mediation process in more detail, as explained by real Utah divorce mediators. Please watch them too. Now, another option for settlement is the collaborative settlement process. On paper, the collaborative settlement process sounds great. It's like mediation in that the parties don't litigate, but meet to negotiate a settlement on their own terms. With the collaborative process, each party is represented by and works with his or her own lawyer. The parties and their lawyers also use other neutral professionals to work with both parties, such as child psychologists, counselors, and accountants, and other professionals as needed or wanted. Collaborative settlement can include a mediator too, but does not require one. A weird aspect of collaborative settlement is that each party's lawyer involved in the collaborative process is prohibited from representing the parties if the parties don't settle and if the case goes to trial. So collaborative law can end up being more expensive and time-consuming if you don't settle. That doesn't mean you can't use a lawyer. It just means you can't use in court the same lawyer you used in your collaborative settlement process. Now let's talk about arbitration. Arbitration is like hiring a private judge, an arbitrator, to hear your case and decide it. They hear testimony, take evidence, and issue binding decisions that are enforceable, the same as a court order. Arbitration is more expensive than public court because the parties have to pay for the arbitrator's services. But if the idea of going to the courthouse or having your case open to the public concerns you, arbitration may be a very attractive alternative. The point of this video is to show you that you have alternatives to court in your divorce case. You can exercise more control over your own case and family with negotiation, mediation, collaborative law, and arbitration. Thank you for watching.